morning to you all participants, and welcome to this training webinar, which focuses on the administrative sanctions framework for Zimbabwe. The reason why we have had to arrange this workshop is we have come to that stage where for a long time we were interacting with reporting entities, financial institutions, and designated non-financial businesses and professions. And we think we have reached a level of awareness where we now need to move a step further. In fact, we have started imposing administrative sanctions on DNFBPs, something which we previously never used to do because we're focusing on awareness raising first. But we think now is the time for us to revisit the framework so that everyone is familiar with it, so that as we proceed, when sanctions are imposed or you receive a notice of intention to impose administrative sanctions, you are well aware of what the framework is like, where it's coming from, and what your recourse is. So I will present a very few slides that I have to share with you. I have tried to simplify it as much as possible because I understand that the audience that we have here is a homogeneous one, or rather it's a diverse one, heterogeneous rather. So I don't want to make it too complicated because we have financial institutions, banks that are probably a little bit more mature in terms of understanding AML safety obligations, but we probably also have some DNFBPs that are a little bit behind. So we'll try to keep it as simple as we can. So I will really begin now to go through my slides. If my slides can be beamed for the audience. So I'll start with the presentation overview. I hope you can all see it on the screen. What I'll start with is just first things first, define what are administrative sanctions in very simple and brief terms. Then after that, I will then give you an overview of the administrative penalty framework as it is set out in the Money Laundering and Proceeds of Crime Act. Then we will also briefly discuss what is in the Administrative Sanctions Directive. Then we'll talk a little bit about imposition of those sanctions by the FIU, then also by competent supervisory authorities and self-regulatory bodies. Finally, I will also want to touch on the procedure itself. In practice, how we have gone about imposing administrative sanctions and some of the issues that we have picked as we were undertaking the process. So, what are administrative sanctions? In very brief terms, maybe I'll start. It's better to start by distinguishing them from criminal sanctions. There are two main forms of sanctions that can be imposed for violation of regulatory obligations. Number one is the criminal sanctions. Those are sanctions imposed by courts, sanctions or penalties imposed by courts following criminal prosecution and conviction for breach of the said statutory provisions. And then apart from criminal sanctions, we then have what we are talking about now, administrative sanctions that are also referred to as civil penalties in some cases. And these are normally imposed by an administrative body for specified breaches of the law. Very often, the same breach of the law can constitute a criminal act, but can also constitute an administrative violation. And sometimes regulators decide whether to refer a certain violation for criminal prosecution or to deal with it. Normally, criminal prosecution, we normally reserve it for more extreme cases, cases where perhaps a financial institution or designated business or profession has actually been found guilty of deliberately facilitating money laundering, aiding or abetting a client to commit money laundering, then that becomes very serious because it's as good as committing money laundering itself. But where the breaches involve just a failure to implement any of your obligations as imposed by law, we normally proceed by way of the administrative sanctions procedure. So in Zimbabwe, there are various bodies that impose administrative sanctions, but in the context of AML-CFT, administrative sanctions are imposed by a regulatory body. Again, in the case of Zimbabwe, the FIU is empowered to impose sanctions for all the AML-CFT violations that are listed in the penalty directive that we'll talk about a little bit later on. But the law also provides for a framework for competent supervisory authorities, that is AML-CFT supervisors, and the various self-regulatory bodies that have AML-CFT supervisory responsibilities to also impose those same sanctions. In fact, of late, we are increasingly encouraging a situation where the sanctions are imposed not by the FIU itself, but by the relevant supervisory body that has primary supervisory responsibility over the particular financial institution or the designated business or profession. So the country's AML-CFT administrative sanctions framework is set out under the Money Laundering and Proceeds of Crime Act, which is Chapter 923. More specifically, it is set out in Section 5, which sets out the comprehensive, in comprehensive way, the various forms of breaches that can attract administrative sanctions and the forms of penalties that can be imposed. Section 5 of the Act that I've alluded to empowers the FIU to issue a directive listing all violations of the law that may be punishable as administrative sanctions. So pursuant to these powers, the FIU has since issued, first we issued an administrative sanctions directive in 2014, but we have since updated and revised this directive and issued a new one in 2024, about a year ago. So it is that administrative penalty directive that sets out a comprehensive list of all the things that would constitute an administrative violation. All we had to do was to go through the Money Laundering and Proceeds of Crime Act, look at all the various obligations imposed on financial institutions and DNFBPs, and then list all of them and indicate that a failure to implement any of those then constitutes the violation. The Act, the Money Laundering and Proceeds of Crime Act, imposes a penalty of a flat penalty of $250,000 US. That is the maximum penalty that we can impose for a single violation. And then it also goes on to set out a daily fine of $500 US, where an entity is required to remedy a breach. For every day that goes without that breach being rectified, a penalty of $500 can also be imposed in addition to the primary penalty of up to, I emphasize up to $250,000 US dollars per violation. So I'll just go through the just a brief list. I'll just list some of the acts that amount to administrative violations under the Penalty Directive. A failure to comply with any obligation relating to customer due diligence, customer identification and customer due diligence, including identity verification of customers, is set out in sections 15 and 18 of the Money Laundering and Process of Crime Act. Any failure to implement any of the obligations set out there are various obligations. Any failure to implement such obligations amounts to an administrative violation. Then also failure to identify and report suspicious transactions, failure to carry out risk assessments as required by Section 12B of the Money Laundering and Process of Crime Act, because of late we are emphasizing a lot the carrying out of risk assessments, because a risk assessment is the prerequisite for any effective MLCFT compliance regime. It should be risk-based. So normally that's the first thing that we look at when we check on whether an institution is complying with its AML safety obligation. The first and foremost is, if you carried out a money laundering risk assessment to understand the risks to which you are exposed, and any failure to do that, we normally will not forgive in terms of imposing administrative penalty, because that's one of the primary obligations. Failure to implement appropriate risk management systems to identify high-risk customers. Failure to have in place a framework to identify politically exposed persons. Failure to take all reasonable measures to identify the source of funds and source of wealth of a customer or beneficial owner of a customer. Failure to exercise the enhanced identification, verification, and ongoing due diligence in respect of high-risk customers. There are effectively 28 violations that can be punished as administrative violations. This directive was issued out and sent out in February 2024, but as part of today's presentation, it can be sent again to participants so that you go through. But I was just giving an example of some of the violations that are listed in the directive. Who can be sanctioned under the civil penalties framework? It is the banks, or rather financial institutions, as defined in the Money Laundering and Process of Crime Act. The Act defines various classes of financial institutions, and then it also defines various classes of designated non-financial businesses or professions. I think by now we are all familiar with these, but examples of financial institutions, it's your banks. Then you have your non-bank financial institutions, who include insurance companies, primarily focusing on life insurance companies. You have your stockbrokers, you have your bureau de change, money remittance service providers, mobile money service providers, microfinance institutions also fall under that category. So there are various types of financial institutions, the banks being the main category of financial institutions, but also the security sector players and the insurance sector players also constitute a significant proportion of the non-bank financial institutions. Then you have your DNFBPs. These are your estate agents, casinos, lawyers, accountants, precious stone and precious metal dealers, car dealers, trust and corporate service providers. These are the different categories of those entities who are liable for administrative penalties in the case of breach. Then in terms of that same Section 5 of the Money Laundering Reports of Crime Act that I alluded to, that sets out the administrative penalties, any employee, agent, director of any of those entities can actually, in their personal capacity, also be liable to be sanctioned. I don't think we have a precedent in which we have imposed the penalties directly on employees, but the fact that that provision is there is meant to ensure that even employees, even directors, I'm here referring to board members, and other entities who are working directly under the institution, persons working under the institution should know that if they contribute to a breach of the animal safety obligations, they can actually be penalized. Probably will reserve this for much more serious forms of violation by the individuals that we feel both the entity should be penalized, but also the individual concerned should also be penalized. And then what are the forms of penalties that can be imposed under the framework? The Section 5 of the Act, from which the penalty powers derive, lists various forms of penalties that we can impose. We can impose a warning, a written warning, that is considered a form of a penalty, because once you get a written warning, it means that sanction can be escalated to something more substantive. So a warning is in itself a penalty because it's hanging over your head, waiting to trigger a more substantive penalty. Then you can impose fine, and then up to a maximum of $250,000, as I have already said. And also, in addition to that, for the every day that the breach remains unremedied, it can attract a penalty of $500 per day until the breach is rectified. This does not apply in every case. There are those cases where we have ordered an institution and given it perhaps a deadline to say by such and such a date you should have done A, B, C. And then that $500 can start reckoning from the date of the deadline if the deadline has not been extended. Then we can impose a corrective order. One can argue that per se it may not be a penalty in itself, but under the Act it's listed as a form of a sanction where you are ordered to do certain things, usually to remedy the breach that would have occurred. We can issue a directive ordering the entity to do certain things as specified in that directive. The FIU can also, and as I said, all these fines can be imposed by the FIU, but they can also be imposed by the competent supervisory authority because they have the extended power deriving from delegated by the FIU. As part of the penalties, we can issue an order for the removal of any employee or director of the institution, or even a shareholder of an institution, if it is deemed that they played a very significant role in a very serious violation. So we can order the removal of an employee of the institution or entity, or if it is a company, even the removal of the whole board of directors if it is found that they were seriously neglectful in playing their oversight role. Again, it's not some decision that we'll normally do lightly. It's normally reserved for the more serious forms of violation. But ultimately, we can issue an order to the primary supervisor, the primary regulatory body that issues or licenses the entity, to commence proceedings for the delicensing of the institution or entity. So if it's a bank, for example, we can issue an order to the Bank Supervision Division of the Central Bank, ordering them to commence proceedings to de-license the entity for serious AML safety violations. The same can happen for an estate agent, can happen to a lawyer, where we can issue a directive to the self-regulatory body to commence proceedings for the de-licensing or deregistration of the entity. Then those are the various forms. Then the procedure. I will come just touch briefly on the procedure that we use. The Act itself does not set out in any comprehensive way the procedure that needs to be followed when we impose administrative sanctions. Not all acts that impose such penalties set out detailed procedures. Where there are no detailed procedures, our law provides that we should follow the law of natural justice, which requires that due process be followed. The entity that is due to be sanctioned should be given an adequate notice of the intention to impose the penalties and give them an opportunity to answer to the charges before the penalty can be issued. So in the absence of such detailed procedures in the Act itself, the procedures that the FIU has tended to adopt is as follows. We commence the process by issuing out a notice of intention to impose the penalty. This is essentially the charge letter that sets out the alleged breaches that we are deemed to have been committed by the institution or entity. They are listed, giving the details. They are listed one by one as the charges, and setting out the facts. And then when that notice is sent out to the institution or entity, we normally give the entity 7 days, 7 working days to respond to the charges as set out in that notice of intention to impose the penalty, or charge letter as you can call it. When the entity receives the letter, like I said, it has 7 days, and then it can write back to the FIU, or if it is a competent supervisory authority that issued the letter, or the self-regulatory body, you write to the penalizing entity responding to the charges as set out in the letter, indicating whether you are admitting the charges or some of them, and indicating which ones you are denying, if any, and then setting out the facts upon which you are denying the charges. Normally, the charge letter itself really clearly spells out what you need to do, the options that you have to admit, or to deny, or to provide evidence supporting your denials if you are denying. Or where you are admitting the charges, the charge letter normally also guides you to then make any submissions that you may want to make on the quantum of the penalty before the final determination is made. So when the entity, if 7 days elapses without the entity having responded as required, the FIU or the penalizing institution, the regulator, is entitled to assume that there is no defense to the charge, and the charge would normally then be confirmed, and then another letter written to you to say you were served with a notice of intention to impose a penalty, a charge letter. You were given 7 days, you did not respond, and therefore the charges have been confirmed. And then either in that confirmation, the penalty may also be set out, or you may be given a further opportunity to make representations as to the quantum of the penalty. So if you do respond again within the 7 days indicated, you would normally, the regulator would consider the submissions that you have made in your response and then make a determination. Sometimes it may turn out that from your responses, the regulator feels they need to call you in for a oral hearing to make further submissions. There is room for that. Or if you actually request to say you want an oral hearing, you normally set out down a date for which you can come and make further representations orally, and then those will be noted before again a final determination can be made. Then once a final determination is made, based on the responses that you would have given, a letter is then sent if you are found guilty, imposing the penalty for the charges for which you have been found guilty. Or if you have not been found guilty of all the charges, again, a letter will be sent out to say, based on the representations that you have been made, you have been found not guilty. And it goes both ways. The law as it stands currently does not provide for an appeal mechanism. We think that's an anomaly, and so it simply allows you to make representations. If a fine had been imposed without you having made representations on the quantum, you can still come back to make those representations. It can be reconsidered. But a consideration is being given to amend the law so that a clear appeal process is set out. We have not, so far on the penalties that we have imposed, we have never seen the need. No one has really indicated the need to appeal. Maybe most people have been happy with the penalties. They simply make representations, and normally the FIU finalizes them. But we recognize the need to have a separate appeal body so that it can hear your appeal independently and then come up with a determination. So by way of a summary of an overview of the framework, I think I can end here. Maybe what I want to also emphasize is that in terms of the international standards on anti-money laundering as set out by the Financial Action Task Force, or FATF, the expectation is that countries should have in place and enforce persuasive, proportionate, and deterrent sanctions. So our sanctions have to meet those international standards. If they are not deterrent enough, if they are not dissuasive enough, then not only the sanctions as set out in the law, but the sanctions as we then impose them once we have gone through the administrative penalty process. So Zimbabwe is going to be assessed starting almost exactly from now, starting in February 2026, under the regional Eastern and Southern Africa Anti-Money Laundering Group's third round of assessments. So how we impose our penalties, the level of penalties that we impose, the range of penalties that we impose, and on whom we impose them is going to be assessed to assess the effectiveness of our AML safety regime. So when we impose these penalties, we are not only incentivizing you to comply, but we are also doing it also to make sure that when we are assessed by the regional and international bodies, we are found to be implementing the best practices in terms of sanctions. I will end my presentation here for the next phase of this webinar.